name is Kim Mutcherson. I'm the co-dean of Rutgers Law School in Camden, and this is The Power of Attorney. I am here today with my colleague, Ellen Goodman, who actually started at Rutgers Law the same year that I started as Rutgers Law, so I feel like we have that special bond. And the episodes that I have done with faculty have been particularly fun for me because you all are doing such amazing things, and it's really nice to hear about it in more detail. So usually what I like to do with folks is a little bit of an origin story and get a sense of how you ended up in legal academia, which of course is not where you started, right? I mean, you were a law firm partner and living the high life, and then decided to come to academia. So what made you decide to do that transition?
So first of all, I'm really happy to be here with you, and also be in academia and have this job, which is such a great job. So I guess maybe what I should start with, what I tell my students all the time is there was no from there to here. There was no straight line, and I just sort of moved with opportunities as they arose. So I don't know, maybe we should start with how I ended up in a law firm doing what I was doing.
Perfect.
Okay. So I went to law school in order to do environmental nonprofit law. And all of my law school jobs, my summer jobs, were in that area. And I worked for United Nations Environment Program in Kenya. I worked for nonprofits. I worked for justice. And then I did what I had been advised to do after my clerkship, which was go to a firm for a couple of years and get experience in environmental law.
Okay.
And so I did that. And at the firm I worked at, you split your time. You pick two different areas. And so I just decided I'll pick another administrative law area, which will be complementary, and that was telecom. And so what happened was I just found the environmental law boring. I found the telecom law really interesting, which was partly a function of the kind of work it was, but it was also just kind of randomly, I found a mentor who was amazing and just ended up suiting me. And so I ended up staying at the firm a lot longer than I had expected, and became a partner. But all the time that I was there, I was writing, and I was lucky enough to be in an area that was very policy oriented.
Mm-hmm. Can I ask you, so I think people often go into law school with a vision of what they want to do with their law degree, frequently based on very little information about what that area of law is actually like to practice. Once you were out in the world and you were doing environmental law, what was it about it that made you think, oh, this isn't as interesting as I hoped it was going to be?
So it's that change is really, really slow in any area, but especially in environmental law, just because of the kind of remedies and statutes that we have. And so now I should say at the firm, although I was doing environmental pro bono, most of the work in any case was not saving the world work.
Right.
But even when I was at the nonprofits, the tools that you have are really to slow things down. And I just found that really unsatisfying because you could file, a NEPA suit or, force the government to do another assessment or an impact statement. But in the end, they were kind of going to do what they wanted to do. And so it didn't suit there's nothing wrong with it, and I totally respect the people who do it, and I love the people who I worked with, but just didn't suit my personality. Right. And I think one of the things I tell students is that as much as you want to find something that you believe in and that you care about, you also need to find something that fits your temperament.
Right, absolutely. Absolutely. And so what you found that fit your temperament was telecom. Can you just describe, when you say telecom, because I feel like that's not a word that we use a lot now.
Yeah.
So when you say telecom, what does that mean? What kind of work were you doing?
So telecommunications, media law in a Washington practice has a lot to do with the FCC and the Federal Communications Commission, the Federal Trade Commission, and the regulation of industries like cable and broadcasting. And then it also involves, as my practice did, also deals and also appellate work, especially in the area of appealing those administrative state rules. I was lucky enough to be doing this in the mid-90s when this thing called the internet came along. So very quickly, what had been kind of a 20th century practice involved with 20th century technologies morphed into brand new questions of first impression about this new technology. And I and another lawyer at the firm, who also ended up going into academia, it fell on us to kind of acquaint the lawyers at the firm with how the internet was going to affect their practices, the legal issues in securities and banking and food and drug regulation. And not that, we had no subject matter expertise in those areas, but we sort of had to peer into the future about how this technology was going to impact them.
Right.
And so I think if you have a kind of academic bent and you like policy, it very much suited that kind of temperament again, and gave me opportunities to write. And so that's sort of how that world opened up for me.
Got it. Would it be fair for me to ask you whether some of the predictions that you were making in the 90s are things that we are living through now?
Yeah, I mean, one in particular, which I like to remind people of this because it's very rare when I feel like I'm on the right side of history. But in the 90s, so this was when the first laws were being passed to regulate, or more specifically, not to regulate the internet. And so people might remember that there was a tax-free zone for e-commerce, as we called it then. And one thing that's very hot right now, which was passed then, was immunity for internet service providers for any of the content that they transmit. And so now this, in part because we had a lot of traditional broadcast clients, and as people who have practiced law know, you tend to absorb the perspectives of your clients. And so I was very sympathetic to our clients feeling that it wasn't fair, that they were subject to defamation lawsuits and all kinds of sort of content liability lawsuits and exposure. And these new entities, this was pre-Facebook and Google, but this was sort of AOL and Prodigy, that they were going to get a free pass and not have to have that sort of moral hazard. And so at the time, I can't say it's because I was so prescient. It's more because I was feeling for my clients. I felt that this might not be there were really good reasons for it, that you wanted to allow this burgeoning new industry to sort of get its sea legs. But I did see that I used to have arguments in those days with sort of people had a very libertarian view of the internet, that it was going to be this incredibly, sort of pro-social domain where there was going to be all free speech and beautiful and break down barriers, and we weren't going to have states anymore. And I felt at the time, no, I don't think so. I think it's going to end up just like our existing media regime, with really powerful players that have a lot of control but no responsibility because they're going to have this immunity. And on that, I was right.
Right. Yeah. Well, we wish you were wrong.
Yeah. Right.
It must have been incredible to be in this area of law, an area of, emerging technology where there were just new things happening on a regular basis. I mean, this sort of constant experience of, we can try to learn from things that we've done before, but how do we translate them into this medium that is so little understood, right, in the beginning? And even now, I would say maybe not so well understood. So that seems like it must have just been so much fun.
Yeah, and it continues to be really fun. I mean, it hasn't stopped. So I think, it's very much of a frontier domain where you're kind of asking always first order questions. And I think now we're asking the same thing about algorithms and AI. What is this beast? How does it get regulated? Should it be regulated? Do we have to rethink the whole kind of administrative, the sort of New Deal administrative structure? And is it just not retrofittable for these new technologies? So that's always the question. And I think in those days, so one of our clients was Microsoft, and one of my jobs, and this is also kind of an answer to why academia, because I just really liked these kind of 360 questions. So one of the things they asked us to do was, I had a stint in Europe, in Brussels, was to ask what became kind of really fundamental questions for that company, which was, how does competition law apply to us when we're, when in terms of our software or in terms of this new frontier of online, as we call it then, online activities. And so all those questions of first impression are kind of what academics do.
Right.
So that was an unusual opportunity. Usually practitioners don't get to do that.
Yeah, absolutely.
But here they did.
That's excellent. And so then you made the transition into academia, but it seems to me that one of the things that's so amazing and exciting about what you do is that you're an academic who is doing some of this sort of, lofty theoretical work, but who's also really grounded in the practicalities and the difficulties of living in the world that we live in now, which I think can sometimes be challenging to balance those two things.
Yeah, I mean, I guess I like to think of my work as bridging sort of policy and academia. And as we've been talking about, in this space, they're not so very far apart as they might be in other spaces. And so, I mean, for example, right now I'm involved in a project which is really working with policymakers to try to develop legislation that deals with some of the things that we're all very concerned about, like deep fakes and algorithmic accountability and bias and in algorithms. And so, they are very interested in a way that I think policymakers aren't always interested in, kind of what the theory would be for this kind of intervention or that kind of intervention. And at the same time, I think academics in my field tend to be, I think, more interested in what's happening on the ground than may be true in other fields.
Do you feel like we can use the rules and lessons that we've learned from older technologies and the older sort of world that we functioned in to make sense of the internet and the deep fakes and the, all the artificial intelligence stuff? And do we have the foundation for that? Or is this really something that we have to build from the bottom up?
I think it's both. So I think there are some, I'll just give you an example. So the concept, for example, of market failure or public goods. So a market failure is when the market is not going to provide for something that you want. So that's a time-honored principle in administrative law. So therefore, you need to find new incentives or subsidies or some way to step in where the market has failed. It's an old concept in media and telecom and every other area of the law. We can use that to identify where there might be market failures in this domain and how to fix them. But then there are things, I think, that are really new. And so when you've got sort of machine learning and AI operating out in the world, so making decisions about housing or making decisions about sentencing and criminal justice, you may need AI and machine learning to contest that. And so, or sometimes we call them antagonistic methods of understanding what's happening, challenging what's happening, sometimes even confusing what's happening to empower people who want to resist sort of algorithmic predictions or surveillance knowledge of them. They might want to use these tools as a modes to resist. So that's all something new.
One of the things that I think can be really fun when you are doing work within really any sort of very specific technical space as a lawyer is that it requires you to understand things that you might otherwise not even necessarily not care about, but not have to have this really sort of deep knowledge of it. So it strikes me that this is an area where you have to understand, how a lot of this technology works in order to then be able to critique it and to think about policy and to think about legislation. Is that fair to say?
I think so. And so I think that's certainly true for litigation, right? You can be a general litigator and what's fun, I think, about that is learning kind of just enough about the fields that are involved. In my area, it's always been true for my whole career that I've had to learn just enough electrical engineering about spectrum or just enough computer science about, how code works or software works. And sometimes that's a challenge. And in some areas, I don't have just enough. I'm not there yet.
Right.
And I think that the role of a lawyer, though, generally is at least in these two areas that we've just mentioned, kind of the administrative law area and litigation. It's probably also true in corporate law, but I know about that less. The role of the lawyer is to be a translator, right? Is to move from one domain into another and get people with domain expertise to explain things to you in ways that you can understand so that then you can translate that for the world.
Right, right. I would love to dive a little deeper into some of the specific work and specific topics that you're focused on now. So one of the things that you've been able to do, sort of thinking about being that bridge between academia and the real world is, work with foundations that have particular projects that they're focused on or topics that they're focused on. Can you talk a little bit about what you're doing right now?
Sure. So I have two different grants now. One is from Democracy Fund, and so I mentioned this work in Washington, this policy work. That's really to support that work and to work with a group called Digital Innovation and Democracy Initiative at the German Marshall Fund, and we are writing reports and sort of doing public communications about what is really kind of a crisis of disinformation and the shaking of the foundations of information that we need for democracy. So that's in the policy space, and that work involves, as I said, coming up with legislative proposals, but more kind of doing white papers and op-eds and addressing some of the things like deep fakes or bot armies that are sowing disinformation. The other grant is from the Knight Foundation, which I haven't started yet, but that will be for research and collaborative research, interdisciplinary research on transparency and the role of transparency in sort of preserving a clean and useful information space, again, to support democracy.
Mm-hmm. So, I mean, one of the things that I think is really hard in the time that we are in now is the extent to which who's in the White House has an impact on some of these larger conversations. So if you're doing anything in DC, the politics have to be a part of it. And there's a piece of me that would like to think, well, this is a space where people across the aisle should be in agreement with each other, right? Everybody should think that if we're in the midst of a crisis of disinformation, that's a thing that we should fix, and we should, people should be able to get on the same page about that. Is that woefully naive for me to think that way, or is it the case that this is one of those things where people of goodwill will agree?
Well, right now there is bipartisan pushback to the platforms, although for different reasons. And so those different reasons are important and lead to different kinds of policy interventions.
Okay. Well, let's talk about the different reasons then. So.
Okay. Well, I mean, so you have Senator Josh Hawley, who's a Republican, who thinks that the platforms disadvantage conservative voices. And so he wants
and by platforms, you mean, Facebook, Twitter, Instagram,
Google, right.
all of it.
He wants an intervention that would require them to be neutral. Then on the left, you have like Senator Warner from Virginia, who thinks that the platforms don't do enough to moderate hate speech and, especially white supremacist speech. And so wants them to be more active in that, which is not being neutral. And so, so they both have problems with the information ecosystem, but for different reasons. Mm-hmm. So my view, no, I don't think you're being naive. Everyone's view about whether or not we have a healthy information environment depends on where you're coming from. Mm-hmm. But so therefore, what is the role of policy proposals and people like me? So I have sort of two responses to that. So one is, and this is, maybe cynical, and you will see, but I kind of think everyone has to feel some pain before they can come to appreciate that disinformation is kind of a bad thing. Or, I think unfortunately it might come to this. So right now, disinformation is rather asymmetric. So the right is using disinformation tactics more than the left, but that's not a law of nature.
Sure.
And, and unfortunately, I think it may take until we have such a polluted information environment where it's a race to the bottom, where everyone can kind of, rise to the surface gasping and say, you know what, this hurts all of us. That's one possibility.
Okay. So we have to sink even lower.
Yeah, we haven't hit bottom yet. But another response I have, and this is just part of my experience doing this work, is that so one might ask, what's the point of doing this work when it's not going to get these bills that you're working on, because no bill is going anywhere.
Mm-hmm.
And I think to do this work, you have to have kind of, the arc of justice is long,
Mm-hmm.
and you have to take the long view. And so there are things that I wrote in 2007, 2008 as part of, for the Obama transition team about a new vision of public media that I think we called it Public Media 2.0, which shows you how old it is. And it didn't go anywhere. And it's only now that some of those ideas are being taken seriously as policy proposals. And so sometimes I think we in academia/policy, there's value to developing these ideas and kind of working them through and getting them on the shelf. And when the time comes, they're there.
Right. Right. I respect that. What do you see? So, part of what we've talked about seems to me to be issues that are time worn, right? Free speech, and how do we protect it, and what should be free and what shouldn't be free, and when do we confine it? One of the topics that seems to me has really come to the fore in really interesting ways, I think now, is what is the role of media in a democracy? What should we expect our media to offer to us? How do we protect the media space? And how do we think about our responsibility, as individuals or as citizens, to consume media in a way that is responsible? And I feel like we're having all of these conversations now. People are, I'm going to cancel my New York Times subscription because they posted this, or I'm not going to watch, MSNBC anymore, or, Fox News is, if you watch Fox News, then your whole view of the world is pushed in a particular direction. What would you say is the role, in your ideal world? What's the role that media should be playing in our democracy right now? And do you feel like it's doing that?
I think we've got a lot of really good media and a lot of really good journalism. Where are the market failures? Some of what you're asking is kind of, what is the intersection between political polarization and media? And that's kind of a bigger question. And there's a lot of, Ezra Klein has a new book about this, about the interaction between media in promoting polarization. Obviously, Fox News has done that, and polarization driving particular kinds of media. There are, really interesting questions about, first of all, these are old questions about what should media be, and how do profit motives drive media in certain directions? What has been the role of deregulation, that started in the 1980s, and the whole neoliberal turn and all of that. So those are all really good questions. But what I want to underscore is that in terms of market failure, and where have we seen the market really failing? So New York Times and Wall Street Journal and national media is, even if people cancel their subscriptions to the New York Times, it's doing really well.
Yeah.
And it's pretty well funded, and the model seems to be hanging in there for them. Where it's not hanging in at all is for local journalism. And, I think, so that's really my interest and my focus is how do we, there's just been a calamitous crash.
Right.
And I think we've lost 35% of local newspapers in the last couple of years.
Right.
And so, in terms of people's real lives, about how City Hall works and whether there's corruption and their garbage doesn't get picked up, nobody's looking at that. And so we have these news deserts. And so a lot of the work that I'm doing in terms of policy proposals about media focuses on that. And that is really a new problem. So the old problems about, is media biased and does commercial media work and what's the role of public media? Those are old questions. But this new question, we have never lived in a republic that doesn't have any local news.
This is the first time I've heard somebody use the term news deserts. And that sort of idea of scarcity and loss is something that we talk about food deserts, and so it makes sense to really be thinking about, but also the way that people get information, and particularly information that's localized for them. So you'll be hearing me talk about news deserts going forward. One of the other things that we talk about a lot is consolidation within media, and we see it in all these different ways. And I think we've become accustomed in some ways to the idea that ultimately everything's owned by 3 or 4 people, right? They may give it different names, and so that consolidation aspect strikes me as something that's also problematic here, that there aren't enough people who have the ability to make sure that those local things stay open or any of that. And that's the thing where on one hand you think, well, we have a structure for that, right? That's why we have antitrust law, and we can sort of break all of that down. But it seems like maybe we haven't been so successful with that within this media space.
Well, so media regulation has always been a complement to antitrust, because antitrust allows for a lot more consolidation than we might be comfortable with in the media in particular. It's not a widget, right? It's something that has a more profound effect on our democracy. And so there used to be sort of media ownership rules that went much further than, and were prospective, right? So antitrust is very reactive. And most of those are gone, and anyway, never dealt with the internet. Now, the internet, we thought we didn't need that because anyone can have a voice, right? And it's absolutely democratic.
Yeah.
But what we've learned is that, one, having a voice, having free speech is not the same as free reach, right? So I didn't make that up. That's Renee DiResta's line. But it's important, right? Because algorithms are what determine your reach, and that is controlled by a couple of companies. And the second thing we've come to understand is that it's very expensive. It's cheap to talk, but it's very expensive to actually do accountability journalism. And so that needs to be funded. Now, I want to say, since we are the New Jersey State Law School, that we in New Jersey have something unique in this regard, which is, and it was something that I worked on, although most of the credit goes to Free Press for getting this done. There was a spectrum auction in New Jersey. So New Jersey's public media, it's unusual, was owned by the state. And the state auction, so NJT, New Jersey Public Television, when there was a spectrum auction of television channels, the state auctioned those channels and got a big fat wad of cash for them. And we pushed for that cash to be allocated for local accountability journalism, which New Jersey happens to have sort of the worst record with, because if you think about it, New Jersey, because it's sandwiched between Philadelphia and New York, doesn't really have an organic media market, so has never had very robust local media. And what it did have got consolidated, and we lost. So we pushed to have a sizable portion of that $150 million allocated, which would have been game-changing. What we got was $5 million, which has been whittled down to $2 million, but that's more than anyone else has ever achieved. And that $2 million is going to something called the Collaborative for Civic Information, and it's going to local journalism startups and also to a university collaborative run out of Montclair. So $2 million doesn't sound like a lot, but this was actually a first ever kind of victory to allocate state funding to civic information.
That's great. Well, congratulations. That's great. I live in a small town in New Jersey, and we have a pretty vibrant local. It's mostly internet based. I think there actually is an actual physical paper, but nobody pays attention to it in its physical form. And it's just extraordinary to me how rich the dialogue is about the stories that come out in that very local paper, right? So, some of it's very depressing, right? A body is found
Mm-hmm.
in Cooper River, or there's been a burglary, or this kind of thing, or it's things like the book festival is coming up, and so there's something very rich about having that space we're getting ready to vote for school board, and we did interviews with each of the candidates for the school board, and I hadn't quite thought about how important that is and maybe unique that is to have that kind of resource. We were talking about news deserts before, and I know that there's a term that I'm not thinking of right now, which is the term for folks who don't have access to the internet. What is that?
Digital divide?
Digital divide, right? And so that's another thing where, there's this scarcity kind of issue, and sort of trying to figure out how do we make sure that people have broad access to this tool that's such an incredibly important tool. And some of it, you see happening with, the resurgence of public libraries as these spaces where people get access to the internet and to computers. Is that a piece of the work that you're doing as well? And sort of thinking about how do we, if we're thinking about democracy, we want to make sure that a very wide range of people have access to these tools.
Yeah, so I wrote a piece once about anchor institutions and broadband access, so that a library is an anchor institution, and they can not only provide access within their walls, but they can actually be hubs for broadband, and they can be sort of a wireless hub that then connects people in that neighborhood. But yeah, so here's another phrase for you, homework gap, which is students who don't have broadband access at home but are asked to do homework,
right?
Have to go to McDonald's,
right.
Or have to use what's happened is that they have to use their phones, they have to use data on their phones, which just can't, it's just not real broadband.
Right.
So yes, the digital divide remains. And, I think one of the sort of frontier issues now is that the ways that can be solved, for example, by giving students free Chromebooks in their school, or by, having link kiosks around, is that what we're asking people to do is to sacrifice privacy in order to gain access. And that's problematic. So you've got sort of a solution to the digital divide, which is surveillance. But yeah, I mean, it's so my friend Larry Irving, who was head of the NTIA, which is a part of the Commerce Department, which deals with telecoms, in the mid-90s coined the term digital divide. And if people follow him on Twitter, they'll see he readily points out that, that the phrase remains very topical.
Absolutely. Yeah. Absolutely. My kids are in middle school. Everybody's required to have a Chromebook. Almost all of their work is done that way. But one of the things that has come up and has become really problematic for the school district is how you control the content of what students can access on their Chromebook. So some of it is things that you would, expect, but some of the ways in which they, confine access are things like you can't search for the word lesbian or gay or transgender, right? Which means that there's a group of students who might actually have very genuine interest in those issues, right? But can't access it because of the way that the system is set up. Or they've started doing things like they block Netflix. You can't have access to things like that. This idea that on one hand you want, particularly young people, I think, because they are growing up in a world where you have to have real fluency, with digital media and with the internet, or you're just not going to be able to function in the world. So you want them to have that kind of access, but they're also kids. And so you want to be able to control what they have access to as well. And do parents get to do that, or does the school system get to do that? Does the state get to do that? And so it seems to me that creates this whole other space of thinking about maybe not necessarily free speech, but thinking about, how do we make sure that whether you're old or young, that you have access to a very wide range of information, but also that we're protecting you at the same time.
Yeah. No, that's an access issue, right? And schools and libraries have always, they have the right under the First Amendment to make decisions like that. One of the things, though, that's new here, I think, is that you have Google in the mix, right? And so Google is loves this market. 80%, I think, has 80% of the market. And so what information is it collecting about kids?
Right.
And how does, that, so we've always had school districts and libraries making these decisions, but now you have a corporate entity in the mix, and it's also kind of some of those decisions are homogenized, across the nation, across the world. And so very old concepts that we have, and so you had asked in the beginning, do I think some of the concepts are evergreen? Like, what can the past teach us? And one of the things I like about now being the age I am is that, things do come around again. And so, a lot of people who don't have any experience in media law aren't familiar with concepts that are now very relevant, like diversity. And I don't mean just diversity in the way, diversity of people, but sort of, or ideas, but also, heterogeneity in governance. And so, we like local control in part because it's heterogeneous. And when you have an entity like Google who's in the mix of what your kid can access and what your kid can say and what data is being gathered, you lose that.
Yeah, absolutely. Well, there are two more things that I want to talk to you about. One is algorithmic justice, which I think is another really great term, and one that lots of people haven't heard. So I'd love for you to talk about algorithmic justice a little bit. But we're also sort of pushing into these questions of privacy and privacy law, and what do you give up by virtue of being a person who can access all of this information, and how do we control how these various platforms like Google and Facebook and Instagram and Twitter, how they use all that information that they're gathering from us. And particularly in a world in which we are regularly signing off on things, right? Not signing off. We just hit that little checkbox, right? That says we agree to all these things that are happening. And, if you could find me a person in this building who has read everything that they've agreed to in order to have access to some of these platforms, I would be very, very shocked. So on one hand, sort of thinking about, are we willingly giving up access to our information to all of these big companies that are using it to profit? And so therefore, is it kind of our fault in doing that? And if we don't want that to be happening, how do we slow that down? So let's talk about that aspect first, and then talk about algorithmic justice.
Right. So our privacy regime has to date been modeled on a kind of notice and consent, caveat emptor, individualistic model. And because, as you suggested, it's not realistic, we need to move towards a different model, which is more of a pollution model, because, and in part because notice and consent doesn't work. So we don't want you opting in to having lead in your water, right?
Right.
We have a decision that it's harmful. And with privacy, it's not just that indiscriminate and excessive data gathering is harmful for you, but that it has negative externalities on the world, right? So that even if you were capable of reading everything and saying, yeah, I'm cool with this, there might be reasons that it hurts other people. And so the best example of that is, genetic information, right? So you might be fine with your genetic information, but it's connected to other people, may not be fine with it. So I think there's widespread agreement, and this was, really, I think, pioneered by academics. Again, it's been simmering for a long time, and people have been developing these papers, and now the world's ready to hear that a pollution model, a collective model that requires some sort of upfront regulation about this is data, even if you can get consent. And sometimes that works through, defaults that are you have to opt into rather than opting out. So that's that. On algorithmic justice, funny you should ask, because we at Rutgers at the law school are trying to really create a center for algorithmic justice. And
tell people what we mean by that phrase when we say algorithmic justice.
Yeah, so it can cover a lot of areas. So for one thing, since we've already talked about access, it definitely covers that. So people often think about, in the context of algorithms, the things that people will be most familiar with are algorithms that discriminate. So especially the sort of first wave of this were revelations that sentencing and parole, predictive algorithms that are used in those contexts to sentence and to make pretrial determinations about parole, that those were discriminatory because the inputs into them to train them were based on historic data, which was discriminatory,
right.
or which mapped onto discriminatory practices. So we don't want that. So we want algorithms that are just. So that's probably what people are most familiar with. But then there are other aspects of this that I think are just as important. So, do you have access to data so that you can train algorithms or be in a space or contest algorithms? So that's part of algorithmic justice. The same way the digital divide is about access. And then, there are other aspects that relate to surveillance. So, I guess I should say not just access. You want access to data. We also talk about privacy as not wanting to be counted. But sometimes algorithmic justice requires that you be counted. And so, an example of that would be the census, right? So there, you want to be counted. You want to get into the database.
Right.
And then there are sort of, broader notions of what is a just algorithmic or AI system in terms of what it's exposing you to. So you may be, because of your data, you may be channeled into certain jobs or have exposure for certain opportunities or be, contacted by certain employers and not others because you're not visible to them because of how your data has been processed. And so, we need to think about, sometimes people talk about serendipity, about like shaking up, obscuring your visibility in ways or confusing the way your data is processed, so that you get sort of sprayed with other opportunities that don't necessarily map onto your profile.
Right. And I think there are lots of ways in which all those things that are happening behind the scenes are so invisible to us, right? And so we're just sort of looking at what's popping up on our screen and not thinking, oh, there are a million different reasons why this popped up and this other thing didn't pop up, even though this other thing might be something that I'm really interested in if I actually had a chance to see it.
And sometimes the response you get to all of this is like, to take the sentencing thing, is you'll hear, okay, but it's more just than what we had before. Or, yeah, but it's always been true that if you didn't know any lawyers, you never thought about being a lawyer.
Right.
And so it's better what we have now. At least you're being exposed to, to being a lawyer. And my response to that is, yeah, okay, it might not be as bad as it was before, but now we have the opportunity to make things a ton better. Right? So,
right. Well, thank you so much for taking the time to talk with me today, Ellen. This is amazing. The work that you do is so critical. It's so important.
Back at you.
Thank you. Thank you. Well, thanks so much.
Thanks.
The Power of Attorney is produced by Rutgers Law School. With 2 locations, minutes from Philadelphia and New York City, Rutgers Law offers the prestige and reputation of a large, nationally known university with a personal, small campus experience. Learn more by visiting law.rutgers.edu.